we've been talking about this all morning. A 20-year-old Queens man facing manslaughter and weapons charges for fatally stabbing a man who was harassing passengers on a Brooklyn J train on Tuesday night. The case very similar to last month's deadly chokehold, which claimed the life of Jordan Neely. But the NYPD's response now being questioned.
Mr. Penny wasn't arrested for a few weeks. There was an investigation. He was at liberty. He was able to turn himself in. There was a bail amount that everyone agreed upon, and he was released in 4 seconds. So why should my client go to Rikers Island when this is the same exact scenario, quite frankly?
Was it self-defense?
So a grand jury did hand down an indictment against Daniel Penny, but it won't be unsealed until Penny is arraigned. So joining us this morning to weigh in on both of these cases is criminal defense attorney Bernarda Villalona. So Bernarda, thank you so much for being with us this morning.
Thank you for having me.
All right, so let's begin with this week's deadly subway encounter in Brooklyn. So the suspect, Jordan Williams, currently being held on multiple charges. Williams' attorney claims that this is the same exact scenario that Daniel Penny faced, but it took nearly 2 weeks before Penny was charged. So will the grand jury get involved in this case, or are there legal differences between the two cases?
Absolutely. So as you can see, between both of the cases, both occurred in New York. It's the same law for both of the cases and the same procedure for both of the cases and the same discretion by both district attorneys' offices as well as NYPD for both cases. So in regards to Jordan Williams, what's going to happen next, because there was an arrest prior to a grand jury presentation, is that the case is going to be presented to a grand jury where the burden is whether there's probable cause to believe that the crime, whatever the crime that's going to be charged, I believe it's manslaughter in the first degree in this case, took place, and whether Jordan Williams is the person who committed that manslaughter charge. So the question would be whether Jordan Williams would testify in the grand jury and let the grand jury know why he decided to use deadly physical force by stabbing this man in order to protect himself, and up to the grand jury to determine whether it was reasonable and whether it was necessary for Jordan Williams to use that deadly physical force and ultimately vote on the charges. It's quite possible that the grand jury can vote to not indict for no true bill, dismissing the case.
You know, so you're talking about the indictments, right, in the grand jury. So let's talk about this. This indictment that was handed down by the grand jury against Daniel Penny. Now, we don't know what is actually in the indictment until Penny was arraigned. Any idea of when that will happen?
So I believe that the arraignment is scheduled for sometime in July. Remember when he was arrested just a couple of weeks ago or a few days ago, that the judge did set a next court date, and that court date was for the district attorney's office to announce whether they did take action, whether there was a presentation to the grand jury, and whether the grand jury did vote on an indictment. So that will happen at the time of arraignment, which I believe is somewhere between July 15th. I'm not sure of the date of that arraignment, or it can be pushed up depending whether the defense attorney in the New York District Attorney's Office decides that they want to advance the case because now there has been an indictment.
Yeah. So he broke his silence, Daniel Penny did, earlier this week, and he continues to claim that he was acting in self-defense and that it wasn't this prolonged chokehold that he was doing. So here's part of what he had to say, and then we'll talk about it on the other side.
I used this hold to restrain him, and I did this by leaving my hand on top of his head to control his body. You can see in the video there's a clear rise and fall of his chest indicating that he was still breathing. And I'm calibrating my grip based on the force that he's exerting. And I was trying to keep him on the ground until the police came.
First, let me ask you this. Do you think as an attorney that it was wise for him to speak so publicly about this case?
Absolutely not. Even though the defense attorney, his attorney, did it in a controlled environment, as you can see. This is something that was controlled by the defense attorney. It's not like he gave an interview to a news outlet or there was an opportunity for a non-partial person to actually ask him questions. It still wasn't a good mood, because when I think about what he said, when he said that he was calibrating his grip based on Mr. Neely's force or what he was doing, it's clear from the video that he wasn't fighting back and he wasn't resisting. If anything, his body was reacting to the loss of oxygen.
And let me ask you this. What's the likelihood, because this is such a racially charged case, it's so high profile, talking about Daniel Penny's case here, that the attorney may ask for a change of venue for the trial, right? Since it's so widely known and so widely talked about.
I highly doubt that a change of venue is going to be granted. Actually, I think for the defense attorney, it's in their benefit to actually keep it in New York County, because when you compare the 5 boroughs, New York County would be the most, in this type of case, given all the factors, will be the most one willing to side with his client. So I doubt that it's going to happen. And when you're talking about a change of venue, you have to show that you're not able to get an impartial, a non-partial jury in that county, and that's not going to happen.
All right. Well, Bernarda Villalona, thanks again for sharing your legal insight with us this morning. We always appreciate your time.
Thank you.